Okay, we're going to go ahead and get started. So today is the second of a three-panel conference on the topic of toward a human right to claim innocence. And the goal of this conference has really been to set out the different pathways that exist for recognizing new rights claims, to think more concretely about what pathways are most suited for the right to claim innocence space, and to really begin to have a conversation about lessons learned from other contexts in which human rights have been sought to be promoted as new protections. Panel 1 occurred yesterday, and it's really a chance just to lay out the ways in which, while there have been significant domestic advances on protecting innocence claims, that has really, somewhat anonymously taken place without any huge input from the international human rights law regime. So you have this domestic progression, with gaps in protection, including around finality rules, but that has been largely without interplay with the international regime. And so we think through in that regard, how do we account for international law's innocence gap? That is the title of a paper that was co-authored by Professor Brandon Garrett, Larry Helfer, who's also joined today. And please, Larry, jump in as you want throughout our discussion. And myself, I'm really thinking through what would be both the value add of having a new human right to claim innocence recognized at the international level, and secondly, what would be the appropriate pathways to go toward that particular rights recognition, and thirdly, what are some of the advantages and disadvantages of pursuing those different pathways to recognize a new right claim to claim innocence. So that was very much the content of our panel yesterday, and it was really meant to be a prelude to the conversation today and tomorrow of getting much more into the weeds on thinking through and learning from other human rights campaigns about how best to advance new rights claims and how to also think through the ways of navigating the challenges as well in advancing new rights claims. And so we're really excited to have today's panel, which comprises 4 experts in various components of this topic. In particular, we'll have, and I'll introduce each speaker individually as we go through, but we'll have the opportunity to first hear from 2 colleagues who have been instrumental, who have been deeply involved and also writing and studying on the different pathways through which we can recognize new rights under international human rights law. And then we also have 2 colleagues who are leaders in the transnational innocence movement, who are really going to invite to reflect directly on how some of those lessons or observations about getting rights recognized in the international level may resonate in the transnational innocence movements space. So the format of our panel today will be to have those 2 presentations by Professors Mart Susi and Inga Winkler, and then to have the reflection on that by our colleagues Sarah Chu and Professor Mong-Hwa Chim, who's joining us at an extraordinary hour in Taiwan. So extra kudos for the 3 a.m. participation happening on that end. But we really are in this panel trying to connect the new rights movement strategies and the innocence movements more directly. So we'll have presentations, and then depending on how we go on timing, I'll ask a couple of questions, but also open to the floor as well, and invite folks to really engage in this interactive conversation that really is meant to be a space for learning about how we can move forward. Okay, so with that long introduction and getting everyone up to speed as to where we were with the panel from yesterday, I'd like to invite Professor Mart Susi to open our panel with his remarks. While we're preparing the PowerPoint that Professor Susi will be using, a couple of things with regard to his bio. Mart Susi is a professor of human rights law and is heading a law program at Tallinn University. He has initiated and is leading several research and development projects funded by the European Commission and the Nordic Council of Ministers. He has edited and is currently editing several research books on the topics of new human rights, the digital dimensions of human rights, and the controversy around the meaning of human rights. He is developing the Internet balancing formula and has lectured on the topic at various universities around the world, including in Europe and South America. He's a management board member of the European Fundamental Rights Agency, the chair of the Global Digital Human Rights Network, and is involved as an expert for the European Commission and non-governmental organizations. That's an extraordinarily impressive bio and of particular relevance for today's conversation is Professor Susi edited the Cambridge Handbook of New Human Rights, which is sort of a very much a playbook for understanding like how new human rights claims can and cannot be advanced. And to that end, we're delighted to be able to benefit from your expertise today, Professor Susi, and I open the floor to you.
Good morning to everybody, and thank you for inviting me and organizing this event, because in today's world, when the traditional human rights are threatened and challenged, it is always important that we do not lose sight of new human rights, which may also emerge. Let me go straight to my presentation. And I have given the heading for the presentation of decrease in universality and abstractness, which is something where that, let me just start the slide. Yes, which is the thesis I have developed in the already mentioned Cambridge Handbook on New Human Rights. Unfortunately, it is not an openly accessible handbook, but I'm sure it is available in major libraries. And this handbook concentrates on three aspects of how new human rights develop. This would be the rhetoric. Rhetoric is how the human rights language is attached to certain new claims, why new human right needs to be advanced. The second aspect is that of recognition, which is about when we could say that the new human rights claim finally has been accepted either regionally or globally. And the third aspect is that of novelty. In the other word, it means why can we say that really there is ground to speak about the human right which is new in comparison to already existing human rights. And my role in this handbook, which is rather it involved about 40 articles, it is about the aspect of novelty. So we shall proceed. And my argument is, first of all, review how a claim of novelty emerges. And we could say we need to track it on time, on the time frame, and would say that the claim of novelty begins when the idea that there is a ground to speak about a new human right has acquired some academic or judicial or political articulation, regionally or globally. Why do I say regionally? For example, you take the right to water. South African Constitutional Court has advanced the idea of the right to water. We could say it's a new human right in South Africa. It may not be a new human right in Iceland, because Iceland doesn't have a concern with water. But what does it mean? The articulation, it is a matter that there needs to be certain discourse. People need to talk about it, people need to discuss it and advance arguments. It is not sufficient where somebody at the height of one's office comes up with an idea and says, okay, I believe here is a wonderful new human right. And the aspect of novelty, it can or usually then will disappear or wither away when this claim of a new human right has acquired a critical mass of recognition. For example, today we speak about several different rights, like rights of the LGBT people, but they were new. They were new at some point several decades ago. Now we no longer can say that these are new human rights because they are widely accepted. But the claim of novelty can also remain in the stage of contestation. In the other words, when no consensus has been reached, whether it is justified to speak about a new human right, recognize a new human right, and that's why the discussion is ongoing. Now, What are the reasons why somebody says we need a new human right? Well, it starts or usually originates from the realization that the present human rights law practice does not provide sufficient degree or adequate protection of two things. Firstly, it can be some important social or political value. I will speak in a few minutes what that really means. And secondly, we could say that adequate protection is not provided towards certain vulnerable or marginalized groups. That the right exists, but it is not enforced adequately towards them. So from here, we can reach the so-called inadequacy of protection thesis. It means that there needs to be verified that someone's or something's protection is not sufficient in order to say that perhaps the situation can be changed through advancing a new human right claim. There are 6 origins of inadequacy of protection claim. 6. Of course, it is a matter of contemplation. Maybe the list can be expanded, but let's be satisfied at this point with the number of 6. Number 1, somebody can use human rights language to want to bring about political change internationally or domestically. Here we can see that the claim of new human right is very much connected to or being an instrument of the political agenda. And I have here some examples. For example, now there is emerging discussion whether there is the so-called new right to consular protection. Yes, it is a political matter. We could say that the freedom from corruption, a very debatable matter, whether it is a human right or not, is certainly a matter of politics. And then the second origin, we could say that there is a push by civil society or special interest groups. And here, of course, we could have many examples. A special interest group or civil society wants to claim that the right to have surrogacy motherhood is a new human right. Certainly rights by indigenous peoples in different parts of the world are pushed by special interest groups. Number 3, we could say that there are some new challenges, primarily technical, towards which or against which the current human rights architecture does not provide sufficient protection. And here we could say that perhaps the digital domain is something where technical advances are going on, or also genetic research. It gives us new possibilities, but also there are new threats. And perhaps the previous human rights architecture was not built or designed to be able to respond to all of these challenges. Number 4, we have specific technological and scientific developments. For example, artificial wombs. This is something which is a result of scientific development. Or I could say that scientifically it is proven now that animals exhibit complex behavioral patterns, and some bigger animals are very much behaving like humans. So we could say that science tells us that the divide between humans and animals is becoming very narrow. Number 5, conceptualization of moral and social values. What do I mean under that? We could say that perhaps the right to land in some countries is being advanced as a new human right because of the specific meaning of the land in the cultural context. Or maybe we could say that there are social reasons to develop the right to housing as a specific human right. And finally, I cannot escape it, it still is possible that the advancement of a new human right claim is a result of someone's intellectual journeys. For example, the right to mental integrity has been proposed in some circles in Germany and United Kingdom. We could say that it is clearly something which the intellect tells us should be developed. Now, I would say that the new human rights in response to inadequate protection, they all can be traced to some uncontested globally accepted human rights. So the parent right is always present. That is something which our research shows. And the new human right, I would say any new human right we have been able to identify so far, either it strengthens a specific aspect of an established right to the extent that separation is justified. We no longer say that, for example, the right to mental integrity is part of right of personality or personal rights or privacy rights, but we can speak of a separate right, the human right. Or it is a response to novel challenges of threat. Now, there are two types of two categories. Number one, the new human rights are connected to the incapability of the discursive practice of established rights to provide sufficient protection to certain groups. Yes, which means, I give some examples: the elderly, LGBT, all need specific protection. But these new human rights are not applicable to everyone. They are applicable only to these specific groups. From here, we can formulate the decrease of universality thesis. Universality decreases because only specific groups can enjoy. And secondly, we could say that the new human right enhances some specific aspect of an established human right. Many different examples can be given, but this leads us to the decrease of abstractness thesis. Yes, new human rights are less abstract than their parent rights. Now, and here are then two developments. New human rights either decrease in universality, meaning they are cared more for specific groups, or in abstractness. And here is the graph, which already has become quite famous, trying to depict how new human rights develop. And you see horizontally, they become from less and less abstract, and vertically, they become more and more individual. The matter is where to put the box. It can be wider, it can be narrower, but I think that shows us some direction how new human rights develop. And my final slide, this approach of decrease of universality and abstractness gives a reply that everything which is socially desirable should not be labeled as a human right, because it cannot. There is also a risk of constitutional collisions. Here is a fundamental question whether the circle of human rights can grow indefinitely, and my abstractness and universality decrease thesis says no, it cannot grow indefinitely. And of course, there is a matter of risk inflation or rights inflation, which is based on the theoretical framework of utility and practice dependency, but it would be a matter of already of another discussion. I was said, my dear colleagues, that I should speak for 15 minutes. My time is over. Thank you very much. Looking forward to comments later.
And thank you, Dr. Susi, in particular for raising at the end, the concerns about rights inflation, and how that can inform state resistance to expanding the corpus of human rights, something we began to have a conversation about yesterday. Thank you too for talking us through, the different ways in which you can think about new rights developing, either for protective spaces for a group or via specific definition of an existing right. And that analysis is really very much anchored in, sort of one of two pathways to rights recognition, right? So we have the derivative pathway to rights recognition and a pathway of recognizing rights through standalone mechanisms. And I think we'll come back to that discussion more as we go through. And with that, I'm delighted to turn to Dr. Inga Winkler, who is also here. Dr. Winkler is an associate professor in international human rights law who takes a social legal approach to her research, which focuses particularly on socioeconomic rights, gender justice, and sustainable development. Her work bridges institutional protection and social cultural dimensions of human rights, global policy and grassroots movements, and critical reflection and practical application. Issues that are considered taboo, in particular sanitation and menstruation, have piqued her interest. Inga is the founder and co-director of the Working Group on Menstrual Health and Gender Justice, and the co-chair of the University Seminar on Menstruation and Society at Columbia University. She served as the legal advisor to the UN Special Rapporteur on the human rights to water and sanitation. Just as a footnote for everyone who's joining us who's outside of the international space, we spent a lot of time yesterday talking about the role of special procedures in the international human rights system. And so we'll look forward to reflecting on that a bit more as well. Dr. Winkler's books include the first comprehensive monograph on the human right to water, the handbook on critical menstruation studies, and an edited volume on the Sustainable Development Goals. So as extraordinary bio would suggest, Dr. Winkler is an expert in many things, but including particularly thinking around the ways we advance new rights claims in the space of socioeconomic rights, such as the right to water. And we're delighted to hear from you. Inga, please, you have the floor.
Wonderful. Well, thank you so much. I'm super happy to be here, and I think it's very much in that capacity. I mean, where Jayne inserted a little footnote that I served as legal advisor to one of these special rapporteurs, and I mean specifically the one on water and sanitation. So I'm mostly going to draw on that experience at the time, kind of this time frame from the late 1990s to kind of 2010 and beyond, kind of this process of how we got to the point of recognizing the human rights to water and sanitation. I always love to talk about menstruation and related stuff, but not going to do that today. So I think the process around the rights to water and sanitation is so interesting because it brings many of these facets that we've been talking about together. I mean, it's this interplay of something that's expert-led and something that also has a political dimension. It's this interplay of processes in the realm of the UN, the Human Rights Council, and other human rights bodies, and the critical role of civil society. And then third, it's the interplay between the global north and the global south, which had a huge impact at the political level. So to take you back just a little bit to the late 1990s, I think we saw this phase where there was increasing recognition, generally speaking, for economic, social, and cultural rights in general. I mean, it was after the Cold War. I mean, there was increasing attention. There were developments on the right to food, the right to housing, the right to health. And at the same time, what we saw, in particular in many Latin American countries, but also the UK, many other countries, we saw huge controversy over the privatization of water services. So that also played a huge role in getting more recognition that water is a huge challenge, basically. So, I mean, we weren't dealing at the time, and even now, I mean, we aren't dealing with anything new in the sense of new technologies, new anything. I mean, water has always been an issue, but I think what we did see is something that was finally recognized as a concern. So against that backdrop, what happened first is that one of these treaty bodies, Committee on Economic, Social, and Cultural Rights, they developed a general comment on the right to water. So that was in 2002, with extensive and very close civil society input, very close to the extent that they were actually drafting parts of the general comment. And I mean, in particular, at the time, it was a Center on Housing Rights and Eviction, which unfortunately no longer exists, but they played a critical role in this process. So what we saw in that level, I mean, obviously is heavy input from civil society, lots of mobilization around it. And we saw this expert-led body, this treaty body, recognizing that there is a right to water. Now, that was a huge step, obviously, but it was very much at this level of expert-driven processes. And what we didn't have at this time was the political recognition, the recognition from states that actually, yes, there is such a thing as the right to water and the right to sanitation. So at that time, Spain and Germany kind of took up this issue and decided that this is something that they would want to take on, that this is something they consider important for various reasons. And what they kind of developed was a three-step initiative where they first thought, well, we're going to give a mandate to the High Commissioner to develop a study on the right to water and the right to sanitation. Where do we stand? Then the second step they envisaged was the appointment of one of these mandate holders in the Human Rights Council. And then the third step that they envisaged was to get a resolution in the Human Rights Council to get water, maybe also sanitation, but certainly water, to get it recognized as a human right. So, I mean, they're Germans, they like to plan. I can say that I'm German. So that was kind of the idea behind it. And I mean, then the first step, as I said, was the High Commissioner, who concluded at the time in that report that yes, it was time to recognize water and sanitation as a human right. But again, that's not yet states doing anything. That's still very much at this expert level. So the next step was the appointment of that mandate holder, and her title was independent expert on the issue of human rights obligations related to access to safe drinking water and sanitation. So it was quite a mouthful, and I think what it shows you, it did not say human rights to water and sanitation. So at that point, Katarina de Albuquerque was appointed as independent expert, and I started working with her a few months into her mandate. And I mean, we developed a set of strategies basically to get to that point of explicitly recognizing the rights to water and sanitation, to think about, I mean, what are the concerns, from different stakeholders, and basically develop strategies to alleviate those concerns. So what we did was really extensive engagement with states, with the private sector, with international organizations, obviously also with civil society and social movements who supported these efforts, but also, I mean, anyone who might have concerns and anyone who was willing, or at least somewhat willing to listen. And I think one of the main arguments that we constantly thought to bring across was that it's not a new human right we are talking about. So it was very much this pathway, I mean, Jayne, what you described as this derivative pathway. I mean, very much, no, we're not talking about anything new. We're just clarifying what's already there. This is part, I mean, in particular, part of the right to an adequate standard of living, and really explaining that water is so fundamental. You really can't conceive of the right to an adequate standard of living without access to water. In a way, I mean, making this argument that it's so fundamental that it wasn't even explicitly mentioned in the covenant. But if you do speak about food, if you speak about housing, if you speak about clothing, then obviously, I mean, water and sanitation would have to be part of that. So I think that is a message we constantly repeated, also very much in response to these critiques about rights inflation, about having too many human rights, and maybe acknowledging that yes, this trend is there, but even if people felt that way, this certainly would not apply to water and sanitation, which are just so basic, so fundamental. And then, I mean, basically, I mean, what we did is, I mean, one big area of work was this collection of good practices, which was mandated in the Human Rights Council resolution. And the whole point of this collection of good practices was basically showing states, to a large extent, you're already doing what you are supposed to be doing under the right to water. So that was part of it. And I think a second part of it was two, I mean, there were several specific points, but I think two really stood out to me. They were kind of the most contentious points. I mean, one was privatization or private sector participation. And I mean, there, I think some of the work we did was really about clarifying that no, human rights law does not rule out privatization, does not rule out private sector participation. I mean, when I look back now at some of this work, I think that debate has definitely evolved. I think has shifted to some extent. And I think if we did that work now, I mean, some of it would look differently. But I think at that point, it was very much about alleviating some of these concerns, and showing, well, I mean, at a very general level, I mean, it does not rule out privatization per se. And the second key concern was about transboundary waters, which is mentioned in a very, very weird way in the actual resolutions of the Human Rights Council. I mean, happy to talk more about that. But I mean, all that kind of build up slowly. And I mean, the idea was really to gain political support, to gain more consensus, to slowly gain traction. But then something happened that almost never happens in the context of the UN, because things suddenly started to move more quickly than we were expected them to be moving. So in the summer of 2010, Bolivia introduced a resolution in the UN General Assembly. So not the Human Rights Council, Intl, where all this had been happening. But in the General Assembly, it was the government of Evo Morales. It was heavily influenced by social movements in the context of Latin America more broadly. And I think all that created very, very interesting dynamics, and certainly also some tensions, where we had this Geneva-led process that had been going on for 2 years at the time. And then we had this sudden movement. I mean, this was early summer. I remember being in New York in June 2010. And then at the end of July, I mean, the resolution was adopted. So it was a very, I mean, for UN standards, a very quick process. There was a lot of tension, some disappointment about the process. There were a lot of states that were quite critical. The US called for a vote on the resolution, but in the end there was no state that voted against the resolution. There were quite a few abstentions, however, and there were lots of explanations of votes, and there was lots of explanations that states were quite unhappy with the process. But in the end, I mean, when you look at it, I mean, not from a state's perspective, but from civil society perspective, social movement perspective, this was the breakthrough. I think this was kind of what made the human rights to water and sanitation what they are. And I think that also points to kind of these distinctions between what happens kind of from a social movement perspective, what happens kind of in the public perception, to and contrasting that with what happens at an expert level or at a legal level. And I think for that, I mean, the resolution was really the breakthrough, to really show, well, there is a right to water, there is a right to sanitation. And I think the way, I mean, that was perceived was really as a standalone right, as something that was recognized by the General Assembly, as something that was recognized as a right. Whereas when you look at it from a legal perspective, and I think that goes to kind of the importance of looking at your audience, I mean, one of the key crucial dimension was a last minute change in the wording. So the original draft of the resolution would have said declare, whereas the final version of the resolution says recognize. And this recognize was kind of the entry point for saying, well, this is not something that the General Assembly just declared out of the blue. It's not something that they just made up. It's something that's firmly grounded already in international law. So you can link this to existing human rights. You can link it to the right to an adequate standard of living, to other human rights. And this is then when you look at the follow-up resolutions, I mean, the Human Rights Council in the same year adopted another resolution that spells this out in much more detail. So I think I'm almost up with time. I mean, if there's time for questions, I mean, I would love to talk more about the right to sanitation, which kind of had a somewhat different dynamic than the right to water. And I don't think we would have gotten to the point of having a right to sanitation without the right to water, because it kind of piggybacked on the right to water. So I think there's an interesting story in that. And I mean, then of course, I mean, after 2010, I mean, many people came to us and kind of suggested that our work was done. I mean, now that we had the recognition of the rights to water and sanitation, but of course the real work had actually just started, because it's not about the recognition, it's about how to actually implement that. And I think for that, I mean, this whole process and kind of this perception as a new human right played a key role in creating momentum and creating open doors with partners that might otherwise not be talking about human rights. So I think that was a really interesting dynamic, I mean, for the following 10, 12 years, and happy to talk more about that as well. So I leave it at that. Thank you so much.
Thank you, Inga. That was just extraordinary. You know, really providing that overview of the different steps and the interplay of the steps that were involved, and particularly like thinking through, as you identified, you know, how do you engage with the biggest challenges around privatization, around transboundary water, But I think too, and I'm really eager to have the group discuss this with you further, like, you know, the ways in which the whole, very much from at least from the Geneva-based advocacy, was really downplaying the newness, like of the right, as a pathway of sort of lesser resistance to recognition. And I think it would be great for us to talk through, you know, that strategy, and again, if you do anything different this time, like if you're starting again, with benefit of hindsight, like, on that. So thank you again. I know that your presentation really gets to a whole bunch of questions that we began having yesterday, and so I hope those who are in the room yesterday and who were here yesterday as well will have a chance to engage directly on that. So thank you for giving us that foundation. So we're now turning to our final two panelists, who are really going to lead us into this process of applying the lessons learned from what Professors Susi and Winkler talked us through, like thinking about it with regard to the transnational innocence movements. What are some of the things that stand out to you as being similar challenges or similar opportunities, and any other reflections too? And we're mindful as well that we have a colleague who's focused on the United States, in particular, and one colleague's focused on Taiwan as well. And so we're looking forward to hearing about those different geographic perspectives as well. I'm going to go first to Sarah Chu. So Sarah joined the Innocence Project in September 2008, and as a senior advisor on forensic science policy, she leads policy work that focuses on improving the valid, reliable, and just application of forensic science and police investigative technologies. She has served as a member of the Scientific Inquiry and Research Subcommittee of the National Commission on Forensic Science, and received the Legal Aid Society's 2021 Magnus Mukuru Award for Integrity in Forensic Science. Sarah graduated from the University of California, San Diego, with bachelor degrees in biochemistry, cell biology, communication, and a master's in biology, and also holds a master's in epidemiology from Stanford University. She is currently a doctoral student in the Criminal Justice Program at John Jay College of Criminal Justice at CUNY Graduate Center. Sarah, we're really delighted for you to join us. I know you've caveated with me that you are not a lawyer, but that you are happy to engage in this space as someone whom is involved from a different perspective. And again, I think reflecting on Dr. Winkler's points, the ways in which civil society has been so critical in these movements around promoting new human rights. We're really grateful to have your perspective on our panel. So thank you.
Oh, thank you so much, Jane. And it is an absolute pleasure to hear Professor Winkler and Professor Susi's work, and to be here with my friend Monghua, Professor Chin. And so, as Jane mentioned, I'm not an attorney. I focus on policy work, specifically domestic policy in the United States at the state and federal level on issues of science, technology, and most recently forensic medicine. And so my comments will be biased in that direction. And what I felt like was or is kind of the opportunity for the United States with the development of a transnational right to innocence is the ability for us to use that platform to leverage protections that have been developed internationally and are not really part of the kind of the normative landscape in the United States. And in particular, I'm thinking about the EU General Data Protection Regulation and the right to privacy that is so well entrenched in the culture of European countries that that is really a right that is being debated in the United States. And to touch on what Professor Susi said, as he was going through hold on, let me scroll down to where my notes were, the inadequacy of protection thesis, that some points from what he presented that I really connected with was the realization that that human rights doesn't allow sufficient protections in the contemporary world as related to technology and scientific development. So the idea that science and technology can modify our conception of protection. And we're seeing that right now with the development of algorithmic AI, big data technologies, and how they're being spread out everywhere. And the risk that this, well, I can say that it's a US generated dogma of move fast and break things, and how that has damaged and hurt society. And so move fast and break things is especially pernicious in the criminal legal system, because for so long, science and technology has been applied in the criminal legal system in the United States without sufficient evaluation of the validity and reliability of technology. And it's been very apparent that the just and equitable implementation of technologies hasn't been contemplated sufficiently. And in the past, the one kind of barrier to kind of rampant use of technologies has been the constitutional right to privacy. And even then, we're seeing that debated in the Supreme Court. And there are some interesting developments there that I think can be enhanced by the by what the GDPR is teaching us about the right to privacy. And so in the GDPR, there's a right to access and the right to correct your information. And I think that they're deeply connected. And so among the challenges that defendants face in the United States is the use of these technologies in the criminal investigative setting, and without discovery or notification. And so what I mean by that is that a person could be identified by facial recognition, which has, in its current state, is generally it's not a foolproof technology. There is evidence that it's racially biased, gender biased, and does not work well on older populations and young populations. So that kind of leaves a very small segment of society that can be accurately identified by facial recognition. And so historically criminalized communities like Black and Brown communities are at special risk. And so a defendant identified by facial recognition may not know that that is how they became the focus of an investigation. And my colleague, Rebecca Brown, who is the policy director at the Innocence Project, conceptualized a term called suspect development. And suspect development is a risk that's created by these surveillance technologies, where it creates an entry point to wrongful convictions by casting this wide net. So the data often loops in many more innocent people than are many more innocent people. And then once an individual becomes the focus of an investigation, that we have seen through DNA exonerations, that tunnel vision can set in and that exculpatory information can be dismissed. And we know that because there are a number of DNA exonerations where the DNA testing was done before trial, that these individuals had already been excluded, and yet their criminal prosecutions continued and they were convicted. And it was later, when that pre-trial DNA exculpatory DNA was recognized, that that their innocence was recognized. And so so we've seen this happen even with something as powerful as DNA. And that and with these algorithmic technologies, one of the kind of jeopardies of these technologies is this concept of like technological superiority, where if it's high tech, it's got to be accurate and it's got to be objective, right? And so we've also learned a lot recently about how the database or the information that's being taken up by these technologies, it really impacts the output. And so if you have racially biased databases, for example, the criminal legal information in the United States, where racially biased policing has generated these databases, whether it's a DNA database or it's a gang database, that it targets and overrepresents historically targeted criminalized groups. And so the ability of individuals to be able to access this information, to know it's even happening, to know what the source code is of the technology that's being used against them in court, that is extremely limited in the United States. And the ability to correct information, also extremely limited, especially when you don't even know what variables are being collected against you. So there's been an increase in the use of risk assessments and social behavior type of databases like gang databases, where your identity is affiliated with criminal identities. And so if you live in a certain zip code, if you have a community of friends that have criminal convictions, that an innocent person can be criminalized through their identity and pop up in these databases that are then used for determining police strategies and activity. Another aspect of the GDPR is the ability to restrict processing. So can people say, no, I don't want my data to be pulled into this giant surveillance system? And the answer right now is no. But it's been interesting that in the Supreme Court, the evolving litigation in the past, I don't know about the current Supreme Court, but the evolving litigation has been focused less on the technology and more on the data. So I think we're no longer thinking about what are the privacy issues related to a cell phone or to a GPS tracker, to a facial recognition system. Rather, we're looking at what information is being pulled out using technologies in general. So one particularly interesting decision was in the Fourth Circuit, where a grassroots group was fought back against the use of aerial surveillance. And the court said that it's not that the use of aerial surveillance was second to the fact that it could pull up all of this information that would determine people's location and all of their activity, and that was the violation of privacy. And so I think that it'll be interesting to see how this Supreme Court continues to evaluate this privacy right to data, and whether or not the United States can recognize these the type of privacy provisions that exist in the EU. And then finally, there's the right to be forgotten, and that connects to innocence and how we think in how people who've been wrongfully convicted or wrongfully accused can return to society. So if once your data is sucked into the system, it's retained and it could be used against you for a lifetime. And in the United States, if you are convicted of a crime, you forfeit all sorts of rights, including rights to your own data, rights to your own genetic information. And so when a person is wrongfully accused and an indictment is dismissed against them, do they have a right to go back and say, hey, all that information you took from me, that DNA sample that you took from me, I want it expunged from the database? That isn't an automatic right in the United States. And we're seeing how this is playing out right now with the legalization of marijuana in some states, but not all, choosing to go back and expunge past marijuana convictions. We're seeing this with exonerees who are trying to live a life free of stigma and still have to deal with their information being in the database, or their names continually being pulled up as associated with horrible crimes that they did not commit. And so I'll close with what Professor Winkler said about how these rights that we would do well to describe these rights as fundamental, and so fundamental that they're obvious. And it would seem that innocence would be so fundamental that it's obvious. And that I hope that through the development of a transnational right to innocence, that that the United States can benefit from the development of rights elsewhere around the world. So thank you so much for this.
Yeah, thank you. That was such an extraordinary reflection on really pulling out like what struck you as being the most key rights framings like in this regard. So like right to privacy, right to be forgotten. Also, I would add to that, because you spoke a lot, the right to non-discrimination, right, which is something that we should be sort of thinking more about and talking more about in the ways in which deprivations of criminal justice have disproportionate impacts on Black and brown communities in the United States and in different country contexts as well. And for really thinking through like how that new right could sort of create a feedback loop to help enhance domestic protections. As we talked about yesterday, even though the domestic law has been ahead of international law on the right to claim innocence, the domestic law space has not been perfect. And there are a whole bunch of protection gaps, as you really talked us through, Sarah, that could be usefully addressed by an umbrella right to claim innocence at the international level. So we're now turning to our colleague, Professor Mong-Hwa Chin. Professor Mong-Hwa Chin is an associate professor of law at National Yang Minchao Tong University School of Law. He is currently the associate dean of the NYCU Office of International Affairs. He's a friend of Duke. He holds an SJD and an LLM from Duke University and an LLM from National Chiao Tong University, double majoring in foreign literature and law during his undergraduate study. Professor Chin's areas of expertise and research encompass criminal justice, evidence, law and psychology, wrongful convictions, and gender and law. He is dedicated to the promotion of gender equality, campus safety, and criminal justice, and has served in several government commissions. He's also a board member of the Tallinn Innocence Project and actively engages in the research of criminal justice issues. Professor Chin, we're delighted to have you here again. Kudos on the hour of participation, and we're really deeply grateful to hear your insights again on these questions from the perspective of Taiwan around, what a new right to claim innocence might look like and how much it would be influential in your space. But thank you again in advance for your comments.
Thank you, Jane. I want to be very clear at the beginning that I'm not an international law scholar. My field is in criminal procedure. So everything that's discussed yesterday and today are very new to me. The several people I am familiar with in the participants are Justin Brooks, Mark Ozzie, and Sarah. They're all Innocence Project people. Okay, so what I'm going to do today is to talk a little bit about the experiences of Taiwan and what's been achieved over the past few years domestically in Taiwan. And let me share my PowerPoint first. So when I think about the right to claim innocence, since I'm a criminal law scholar, I thought about procedural rights. And so when I think about the right to claim innocence, I immediately think of about how to actually help make meaningful reforms to help innocence projects around the world to exonerate people. And I would like to promote the idea of, instead of claiming a new right to innocence, it could be more effective if we reframe the question and to try to persuade the international community to accept the right to allow criminal defendants, regardless of whether it's pre-conviction or post-conviction, to have access to favorable evidence. I think that is a more practical way of tackling this issue of wrongful conviction. I would like to start, and this is exactly the pathway that Taiwan's taken over the past few years. And I would like to start with Article 95 of Taiwan's Code of Criminal Procedure. So Article 95 is Taiwan's version of Miranda warnings. And I would like to ask everyone's attention on the subparagraph 4 of paragraph 1. The sentence says that the right to request an investigation on evidence favorable to the defendant. So when the accused is being questioned, is being interrogated by the police, prosecutor, or the judge in Taiwan, this warning has to be given to the defendant, and the defendant essentially have the right to request an investigation on favorable evidence. And this right is, I think, for most US trained lawyers, this is rather extraordinary, because this right basically allows the defendant to ask the police, the prosecutor, or the court to do investigation on the defendant's behalf. So basically the defendant can ask, for example, if it's during trial, basically the defendant can ask the judge to subpoena a document that might be considered favorable to the defendant, or call a witness to testify, to call to give testimony that might be favorable to the defendant, or even as an expert witness to conduct tests that might be favorable to the defendant. And this is something that's not within the U.S. law, but these kinds of rules are not well. It's not special for a civil law country like Taiwan. A lot of civil law countries share the same rule on this kind of rights. And I also like to talk a little bit about Article 163. Again, paragraph 1 says a party, agent, defense attorney, or assistant may request to investigate the evidence and may question a witness, an expert witness, or the accused during the examination of evidence. Well, the rule basically says that the defendant can ask the court during trial to do investigation. And paragraph 2 says the court may, for the purpose of discovering the truth, sui sponte, investigate the evidence. So even without the defendant making a request, the judge can investigate favorable evidence for the defendant at trial, during trial. So this again is part of Taiwan's civil law tradition. It allows the defendant to ask the state to produce favorable evidence on his or her behalf. But that kind of investigative rights, that kind of asking the state to produce favorable evidence stays only at trial level. So in 2016, the Taiwan legislation, inspired by the US wrongful conviction movement, Innocence movement, adopted the Post-Conviction DNA Testing Act. So it basically pushes the rights to ask for favorable evidence a little bit further beyond trial. And the text basically says that if the result of DNA identification of the evidence associated with the case can be regarded as new fact or new evidence under the Code of Criminal Procedure, then after a conviction becomes final, the defendant can ask the court to retest or do further testing, DNA testing, on what is left on the evidence. And after this new law is being adopted, our courts basically recognizes that the right for the accused to request an investigation of favorable evidence extends beyond trial and into post-conviction realm. And this eventually leads to the 2020 revision on the Code of Criminal Procedure. So Article 429-3 says that a petition for retrial may be accompanied by a motion for the investigation of evidence. So this is within the post-conviction law, and as long as the petitioner states the reason for such a motion, which the court should allow if it deems necessary. The court, for the purpose of making a decision on whether the petition for trial is with good reason, may sui sponte investigate the evidence. So basically, in 2020, our legislature eventually recognizes that the right to ask the state to investigate for favorable evidence for the defendant extends into post-conviction law. And within the legislative note for Article 229-3, it says that a petition for retrial requires new evidence, but evidence is usually possessed by the state or private businesses or private individuals. Unless the court intervenes, one cannot expect a petitioner for retrial to have access to relevant evidence required for petition. So basically, the legislature recognizes that it is extremely hard for people who are claiming innocent to produce new facts or new evidence that is required for post-conviction relief. And so it is necessary to extend what exists, the rights that exist at trial level into post-conviction procedures. So this is a question I would like to ask everyone on the panel, that can we make the right to have access to favorable evidence and international human rights? And based on what I heard yesterday and today, I think by reframing the right to claim innocence into the right to have access to favorable evidence might be more appealing to most countries, because it's not a new right. It's a derivative right from the right to fair trial. And for American lawyers in the United States, American law has what we call Brady rights, right? The state has to disclose everything that is favorable, might be considered favorable to the defendant. So the right to have access to favorable evidence is not, it does not look strange to American lawyers. And it is very precise, and it is very fundamental. And it could even include include the changes in technology, right? Because if the defendant have the right to have access to favorable evidence, it also could extend into asking expert witness to do retest or to conduct further investigation based on new technology. So for me, as a criminal procedure scholar, reframing the issue into the right to have access to favorable evidence might be a more practical and effective way of achieving the right to claim innocence. And I'll stop here. Thank you very much.
Thank you again for that great presentation. And I was really struck by, as you were presenting, how much this like stock take of the experience in different domestic jurisdictions is so key for understanding what state practice looks like in this regard. And for me, it was very much reminiscent of what Dr. Winkler described, in terms of the mandating the study by OHCHR on domestic practices, and also the appointment of a mandate holder to also review and identify where there was not only human rights obligations that were relevant, but also should sort of figure out, are these procedural components shared across different jurisdictions, or are they more concentrated in civil versus common, law, and et cetera. So I really appreciate you bringing that sort of component to our discussion to think through what that would lead to and where it would fit. I also wanted to reflect on, you had mentioned the role of private possession of information too, and I think something that really stood out for me in Dr. Winkler's presentation, also Dr. Susi as well, around new tech and the role of new tech and human rights is thinking through how much would a new right to claim innocence or a different formulation of that also enable us to reach private stakeholders, non-governmental stakeholders in this space who impact on human rights enjoyment in a large degree. And I finally thought, you really, and I'm very interested for if we have time today, but if not, definitely tomorrow, to reflect on this question of the procedural versus substantive parts of the rights guarantee, right? Something that we definitely struggle with a little bit too, but I think your presentation in writing the article, that's referring we being Professors Garrett, Helfer, and myself, thinking through how much we set out these granular components, or whether there was, room to have that detail left to states in implementing, a generic or more capacious right to claim innocence that could be particularized according to each governmental practice. But I think I really enjoyed the invite and the question on this moment, and I think it's something that Professors Susi and Winkler can reflect on too. Is there a benefit to a much more narrowly tailored procedural component of the right, or is there a benefit to framing a right in a broad way and leaving it to states to develop the individualized protection? So thank you for putting those great questions on the table. We have really rich presentations and a lot to engage with, and I want to make sure that I give a chance for folks who are in the Zoom room to engage directly. I have many questions, but I'm going to just take a moment and defer to the floor. Amy, I just want to note very quickly, just so you know, the chat is disabled. So I don't know if folks are trying to use the chat function, they may not be able to do so. But so just to note that if we can have that enabled, but if we can't, let's go ahead and start taking these great questions from the floor. Mark, I think you had your hand up first and the floor is yours.
Thank you. I have a ton of questions, so I will try to be narrow and then come back if there's time later so that I don't hog the entire question time. But my question, I guess my first one is for Dr. Winkler, which I found the description of the long campaign for water to be extremely helpful and sort of the information that I've been longing for a long time. But because this is so new to me, I have very sort of basic questions. But so you started off talking about how the first thing was you got this general comment started from a treaty body, and then sort of stage 2 is going to the Human Rights Council. So my question is just very practical. So how do you get the attention of a treaty body? I mean, we're just a bunch of people sitting around talking about this and nobody knows how to how do you get these first things started? How did you get the attention of a treaty body to write a general comment?
Would you like to respond, Dr. Winkler, right away? Would that be helpful?
Sure, whichever way you prefer. I mean, I think at the time, I mean, there were very close connections between the people who were pushing for this and then people on the committee. So I mean, it was Ibe Riedel at the time who was instrumental, I mean, in really drafting the general comment, and he was a committee member on the Committee on Economic, Social, and Cultural Rights. And I think seeing committee members around the room, I think that might also be helpful. So I think having these, I think that's what we usually don't reflect on. I mean, certainly not what when we look at textbooks. I mean, these personal connections, I think, play a huge role, and whether people are able to get along with each other. And then I think moving forward, I mean, from the treaty body to then the political level, and I mean, all the negotiations, everything that took place, I think what made a huge difference is, I mean, that Katarina de Albuquerque is a very experienced diplomat, that when she took on the mandate, I mean, she had just finished negotiating the optional protocol to the social covenant. So she knew, and I mean, obviously still knows, I mean, so many of the delegations in Geneva. She knew kind of how to handle the room. She knew how to find supporters, who to speak to first, I mean, within the regional groups of the Human Rights Council and the UN, to then get other states to be on board. So I mean, what happened basically, I mean, whenever we were in Geneva, there were endless meetings. I mean, we would basically sit in one of the cafeterias and then just stay there for a day and take one meeting after the other, and just talk to lots and lots of people. And I think those that relationship building, I think is absolutely crucial. And I think obviously having someone who knows that system, and I mean, who can make that initial way in, is obviously really helpful. And I think that's also, I mean, that's one of the huge critiques of the UN, that it's not easily accessible, and that it's not easy to find your way around.
I have many other questions, but I won't hog the floor. I'll come back if there's time.
Great, Mark. We'll definitely come back to you, because I know this is exactly what you've been craving, like the detail on how to operationalize these spaces. So we look forward to those ongoing questions. Professor Alvarez.
Yes, thank you. This was a most enjoyable presentation, but I guess, and I apologize that I didn't go to the first, couldn't go. I was actually teaching for the first panel, but I want to remind folks that this is a presentation inside the U.S. Asia Law Institute. So how do we think about this issue in the context of a number of countries in Asia that are hugely resistant to international human rights? And I draw that conclusion from not just the fact that we don't have a regional Asian human rights court, but from the fact when I look down at the ICCPR, which is the one treaty, is Article 14, specifically paragraphs 5 and 6, where I think many people would draw the conclusion that you do have already a right to what you guys call innocence, but really I see it much more in line with Professor Chin's argument of how this would actually practically come about just through the application of that. But when I look at the ICCPR, yes, there are a lot of ratifications in the huge region we call Asia, but precious few countries have ratified, say, the optional protocol. Only Philippines, as I see, maybe Korea, and New Zealand, which is exceptional for other reasons. So therefore, I don't detect a strong backing for the serious part of the global human rights system. And therefore, I guess I want to pose that, and by the way, I'm also someone who takes seriously Philip Alston's old article from Agile, 1984, Conjuring Up New Human Rights, a proposal for quality control, where even the foremost human rights advocate in the planet was always worried about new fashioned rights. So I think that Professor Winkler, you're probably right, that the most effective way is to try to embed it in something we already have. But here's my question, which is that when I listen to Professor Chin, which makes a lot of sense, what seems to be the idea is, well, let's go to the right to access to favorable evidence, draw from that an international human rights that is procedurally precise, and then make sure we implement it. But I guess given the backlash and questions I have about international human rights, why go through that? That is, why not just eliminate the middleman? That is, why, as we study other places that are influenced by their countries that they're most influenced by, why not do this through a comparative exercise in what are best practices in criminal procedure that are already in our law, and drawing from Taiwan's and perhaps other domestic reforms? In other words, do we need to internationalize this to actually make this implementable and attractive? Because I think once you internationalize it, even if you do it through, say, a General Assembly resolution that would say this is now embedded in the ICCPR, I think you're already running into the backlash issues. Whereas you sell this as part of your rule of law reforms that other countries that you like to compare yourself with, especially other countries that you have civil law connections to, and perhaps a history of reforms being borrowed within a region or even close neighbors, why not go that way? Comparative law, rule of law approaches, rather than going up in order to go down. Now, go up to the international level only to have that implemented, knowing that there's a huge gap between states saying, yes, I agree in a hypocritical way to the international human rights, but never getting around to implementing it.
Yeah, and thank you for that. Exactly, that question around, essentially, what is the value add of pursuing a rights recognition, like in this way? And maybe I would invite, so we talked about that quite a lot yesterday, but I would invite maybe Professor Helfer, when he asks his question, to reflect on that a little bit too. But I want to open that question up to the group. And I think also inherent in Professor Alvarez's comments are definitely a pushback and the backlash point you can get from states about rights inflation, right? Like, essentially, are you adding to this body of the rights corpus in ways that unduly expand the human rights protection regime? So maybe, Dr. Winkler, do you want to reflect on this question of, like, why did you argue for a right to water? Like, why not rest on existing domestic practice? Like, what was the impetus for a new rights claim that was capacious in its formulation, right? It wasn't going through and developing these procedural components, what that might look like. And maybe Professor Susi, you can also reflect on this too, like, this question of, like, whether you think, how do you manage these questions of rights inflation, right? Which is so key in this discussion as well. If we can do that, that would be great. And then we'll go to you, Professor Helfer, as well.
Yeah, I'll be brief, because I'm not sure to what extent the situations are really comparable. I think when we look at the right to water and we look at the right to water at the time, there wasn't a whole lot to go on in constitution. There was a handful of constitutions. I mean, maybe we are, I haven't counted, but it's still below 20, I think, that constitutions we have the right to water embedded. So, and I think when we looked at kind of what social movements were calling for, there was a demand for the right to water, and I think there were issues, but there wasn't, this whole question of backlash maybe wasn't as pronounced as it is now, because we're talking 15 years ago, right? Yeah, so I think the dynamics were slightly different. And then early on, going back to this earlier point about building support and talking with everyone, there was a transnational coalition of states that really supported this. And I think that really made a huge difference. So maybe the dynamics were really slightly different. And but I think the comparative element is really interesting. And more recently, I've been involved in a research project that really looks transnationally at how the right to water and its actual implementation, how it's being constructed. And what we found that, across countries, from several Latin American countries to India to South Africa to the US, is that the national, plays a much bigger role. What's happening at the national level, what's happening through domestic courts, what's happening through social movement at the national level. The international recognition kind of plays into that, but the national level, played a much bigger role, and including the comparative element. So I think that's a really interesting point.
Can I clarify, Dr. Winkler? I think this is for everyone to understand. That review of that cross-country, the comparative piece, is an inherent part of what you did, right? Well, what the OHCR...
Oh, no, this was much later.
Yeah, but so, no, sorry, what the OHCHR, when they mandated the study on the right to water, and so, for example, that was what was done with regard to the right to a healthy environment by the then SR John Knox, is to do exactly the type of process that Professor Alvarez is talking about, which and Professor Chin is encouraged us to do too, which is a total stock take, right? That we don't enter these discussions without a comprehensive review of the national level practice. I want to be just clear that these are not we're not evacuating a review of national processes like from this overarching approach to establishing a new right.
Yeah, and I think John Knox did that. I mean, probably more extensively than anyone else. I mean, their stock taking. I mean, that they did, and also, I mean, given that the right to a healthy environment is recognized in so many national constitutions, or in some way at the national level. I mean, there was so much stock taking they had to do. So I think that's a really interesting process to follow. But I think in that regard, again, it was quite different from the right to water, and certainly the right to sanitation, where there wasn't that much to go on in national constitutions.
Thank you. Professor Susi, would you like to respond on any of these points? And then I'll turn to you, Professor Helfer, as well.
Yes, indeed. Thank you. Well, when I have been contemplating about now listening to this proposition of the right to favorable evidence and if it could be justified as a new self-standing human right, I have two issues. First of all, I would say that clearly under this decrease in universality and abstractness thesis, it would be difficult to justify that it has components necessary to say why we need it separated from the right of fair trial or right to be assumed innocent. But of course, that was something which already Professor Shin touched upon. But here is another matter which came to me. I have been contemplating about that. And it is the following: whether we could say that the strength of new human rights, which are derivate rights or which are implied through already well or from already well established human rights, whether their strength decreases. In the other words, what would help a person more? Whether a person's case would be stronger if the person says, I claim a fair trial right and the right to be assumed innocent, which is something everybody understands. There is a long history of those rights. Or whether it would help somebody more if to say, well, I claim I put on the table now this new human right to favorable innocence or to favorable evidence. And something in me tells that the case will be stronger if one can put on the table well-established traditional rights. But that is something I will just limit myself to because of the time matter, but something we need to take into account. What will be really the power of new human rights in comparison with well-established rights? Thank you.
And thank you for bringing us back to that, Professor Susi, like really thinking through like what is a protection gap that is being closed in this regard. It's such a helpful reminder of, and again, the need for that transnational review of the different approaches. Larry Helfer.
Thank you, Jane, and thanks to all the panelists. It was really super interesting interventions and discussion. A couple of thoughts in response to the conversation that we have been having now. I guess first to Jose, you're absolutely right to raise these cautionary points about backlash and quality control. And indeed, in the paper that Jane and Brandon and I wrote that we discussed yesterday, we take those very much to heart. And in fact, what's interesting about this area is that we actually have what you correctly describe as the comparative approach that's gone on for quite a couple of decades anyway, including countries in Asia. And what the striking thing is, unlike many of the other initiatives, which, as Professor Winkler was suggesting, well, there wasn't so much about the right to water, and so it started kind of top down, and now it's moving from the top to the bottom. In this area, we see lots and lots of comparative developments, including some who are not the usual suspects. At the same time, and we actually also have a number of best practices. We talk about a judicial model, an administrative model, there are quite a few, but we still have protection gaps. And so the question, I suppose, is, to be blunt about it, is, are the benefits of internationalizing, recognizing this as a derivative or freestanding right, which are the two pathways in Professor Susi's book, primarily, do they outweigh the benefits of continuing the comparative law approach? And I think that's a very serious point of discussion, and we should have more debate about it. I think it's worth keeping in mind that we're talking about countries not just obviously in Asia, but countries that are somewhat more open to having their courts or national human rights institutions or other kinds of bodies that focus on criminal legal reform being able to take account of international human rights law. Recognizing, of course, Jose entirely correctly, the weaknesses of those processes and institutions and the fact that most of the norms are either formally or practically non-binding. So that then leads me very briefly to a response to Mark. And now I have to say that I'm speaking in my individual capacity, not as in my capacity as a future member of the Human Rights Committee. And that is that general comments are started somewhat differently in different treaty bodies. So the Committee on Economic, Social, and Cultural Rights has been more open to thinking about creatively about fashioning new rights that are, or derivative rights that are implicit but not textually grounded in the Economic and Social Rights Covenant. The Human Rights Committee has been somewhat more cautious in developing its points within the context of textually enumerated rights in the ICCPR. Having said that, the committee has marked a place in the comment on the right to life with respect to post-conviction claims of innocence and exculpatory evidence like DNA evidence in the context of death penalty proceedings. So there is a toehold there for development. And the question is, what might be the way of developing that toehold? It certainly can be the case that the committee can, in its review of country reports, which it does for quite a few countries in every of its session, ask about these issues so we can have a better factual foundation for comparative law analysis. And maybe the conclusion will be among civil society groups and scholars and activists, okay, let's stop there. Let's use the international system to gather more information and not go further. Or we might start thinking about other modalities. So maybe I'll just stop there.
I think it's actually a great point on which to end, given that we've got the panel tomorrow that's being chaired by Larry on the right to a healthy environment, which will exactly get into the nitty-gritty of these modalities even more. I also just want to be really thankful to all of our panelists today for, again, really taking us into both the big and the small questions around operationalizing new human rights guarantees, and then to provide those preliminary reflections and questioning, about how these do or don't translate into the innocence context. I really hope in particular, and Doctors Susi and Winkler, you're new to this conversation from the perspective of being involved in the transnational innocence movement, and I really hope that our colleagues here can continue to draw on your extensive expertise around lessons learned and also cautionary tales about thinking about rights inflation as we go forward too. And I want to again thank you for giving your dedicated time to engaging in this conversation at this really critical juncture in the movement's work.